Hello and welcome to The Legal Brief, a short-form video analysis of emerging and hot legal topics. My name is Bryan Jacoutot. I'm an employment attorney here at Taylor English Duma. Today we'll be discussing restrictive covenants, specifically a recent case out of the Court of Appeals of Georgia that arose under the Restrictive Covenant Act, passed by the legislature in 2011. Before getting into the case, however, it's important to note, again, this is a relatively new act here in Georgia. The legislature passed it in 2011. And the goal of it was essentially to sort of clarify and make it easier to understand an employer and employee's respective obligations when they enter into these restrictive covenant agreements. Of course, it's a very nice thought. However, so often the case in the law, all these attempts at clarifying ambiguities in the common law through statute result in their own unique ambiguities and issues that people have when trying to enforce them. So before we get into the legal aspects of this case, a quick look at the factual background helps. The plaintiff in the case, which is styled Kennedy versus Shave Barber Co. Again, this was at the Court of Appeals. The plaintiff is Patricia Kennedy, and she's basically a hairstylist for a barbershop over in Virginia Highlands in Atlanta. Patricia, in the course of her employment, decided to sign a non-compete agreement and a non-solicitation agreement with her former employer. First, looking at the non-compete agreement, the provision says that for a period of 2 years after her employment, she would not directly or indirectly compete with the shave. And she would not do that for, again, a time period of 2 years, and the geographic radius in which she agreed not to compete was 3 miles. The non-solicitation provision provided that she would not solicit for any business in the barber or salon or men's grooming industry any customer or potential customer of the shave. This would include anyone that she was had personal contact with or otherwise was introduced to during the term of her employment. Also important was that in the agreement that Patricia Kennedy signed, she agreed to the fact and acknowledged the fact that she customarily and regularly would solicit customers for the shave and on behalf of the shave. Now, despite the fact that Kennedy signed these restrictive covenants, she actually opened up her own competing barbershop 2.1 miles down the road, and she started soliciting customers and performing the basic duties of a barber. And when the shave found out about this, they sued her, basically saying that she violated both her non-solicitation and her non-compete agreements. Both at the trial court level and at the Court of Appeals level, the courts all agreed with the shave, saying essentially that Kennedy had violated her non-compete and that she would not be allowed to compete directly with the Shave Barber Company within that 3-mile radius. And so the question is why? Why did the courts decide to uphold these restrictive covenants? In order to understand that, it's important to note some general aspects of restrictive covenants in Georgia, and that is that they will generally be upheld if they are reasonable in time, geographic scope, and scope of prohibited activities. Another unique factor of restrictive covenants in Georgia is that because of the Restrictive Covenant Act, they only apply to specific types of employees. For our purposes, the type of employee that Ms. Kennedy was one that would regularly and customarily solicit customers for the business. So that's a covered employee under the Georgia Restrictive Covenant Act. So knowing that she is the type of employee covered, we have to answer those 3 questions about the reasonableness of the restrictive covenants, whether they're reasonable in time, geographic scope, and scope of prohibited activity. Turning first to time, the restriction was 2 years. And the court said that is a reasonable amount of time, and that generally Georgia courts are going to construe a 2-year time limitation as presumptively reasonable. If you get any longer than that, you're running into some issues about it being too long, but 2 years is presumptively reasonable. Anything shorter than that will be fine as well. So the next factor is geographic scope. In this case, it was a 3-mile radius of the shave location. This one gets a little bit tricky because the wording of the restrictive covenant was that it would be 3-mile radius of any shave location. And while at this time there's only one shave location, there's an obvious possibility that there might one day be more. So Ms. Kennedy could be actively abiding by her non-compete and open up a shop 15 miles away, and then the shave could potentially open up a shop right next door, and then she would be in violation of the non-compete. So what the court did to reconcile this is what's called blue penciling, and that's basically where the court makes something that is an unreasonable provision and renders it reasonable. In this case, they blue penciled out the fact that it was any shave location and made it so that the provision essentially read that she was prohibited within a 3-mile radius of the current shave location that she previously worked at. And with that blue penciling, the court said, okay, this provision is now reasonable, so let's move on to the scope of prohibited activities. The court found that the prohibition was fine, and they stated that the agreement does not preclude Kennedy from working at a retail establishment that sells hair care grooming products, but maybe doesn't provide styling service within the 3-mile radius of the shave, nor does it generally preclude her from directly competing as long as she's outside that 3-mile radius. So in light of that, the court said that the scope of the prohibition was not unreasonable and agreed to uphold that. So to wrap all this up, because Kennedy signed the agreement and she was the type of employee that is specifically contemplated by the Restrictive Covenant Act, specifically one, in this case, that customarily and regularly solicits employees for business, because she was that type of employee, and because the restrictive covenants that she signed were reasonable in both time, geographic scope, and scope of prohibited activities, the courts have ruled that the restrictive covenant can be upheld, and Ms. Kennedy cannot compete directly with her former employer in that 3-mile radius.